Nnamdi Kanu's trial, a natural disgrace, lawyer. A human rights lawyer and the Director of Legal Affairs, Research and Global Communications of the Indigenous People of Biafra (IPOB), Barrister Onyedikachi Ifedi, has taken a swipe at the Nigerian government over the continued trial of Mazi Nnamdi Kanu. The lawyer described the landmark judgment by the Kenya High Court as a direct judicial indictment of the Nigerian government under the watch of a former Attorney General Abubakar Malawi. Onyedikachi accused Malawi of overseeing what he described as an international criminal operation that has now exposed Nigeria to multiple counts of treaty violations, state-sponsored terrorism, and grave human rights abuse. He stated this in a statement he signed and made available to journalists on Monday in Abuja. He called on a Tinubu-led government to end the ongoing sham trial and take steps to comply with the judgment of the Federal High Court, Umuahia Division, and the High Court of Kenya. The statement read, "We wish to commend the High Court of Kenya for its landmark ruling that declared the adoption, detentions, and forcefully transfer of Mazi Nnamdi Kanu from Kenya to Nigeria as a flagrant violation of his fundamental rights, including the right of liberty, fair hearings, and the due process of law, as guaranteed under both the Kenyan and the Nigerian constitution, as well as international legal instruments, which Nigeria is a signatory." These rulings is not merely a vindication of Mazi Kanu's long-standing position. It is a direct judicial indictment of the lawlessness perpetrated by the Nigerian government under the watch of the former Attorney General Abubakar Malawi, who supervised this international criminal operation that now exposed Nigeria to multiple counts of treaty violations, state-sponsored terrorism, grave human rights abuse. Now that a competent court in Kenya, the territory from which Mazi Nnamdi Kanu was adopted, has issued a reason, courageous and ambiguous judgment, the Federal High Court sitting in Abuja can now no longer pretend that the question of illegal rendition is irrelevant. In fact, by virtue of the Nigeria Terrorism Prevention and the Prohibition Act 2022, His Lordship Justice James Omotoshi is under a legal obligation to inquire into the jurisdictional properties of the trial, including whether the foundation of his entire case is tainted by illegality. Indeed, Section 23F2 of the Terrorism Prevention and the Prohibition Act 2022 provides verbatim as follows: "An act which deliberately violates the provision of any international treaty or resolution to which Nigeria is a party subject on the provision of Section 12(1) of the Constitution of the Federal Republic of Nigeria 1999-2 by unlawfully seizing, kidnapping, or adopting any person shall be regarded as an act of terrorism under this act." This provision is clear, ambiguous, and devastating in its implication. Any Nigerian officials, civilian or military, involved in the adoption of Mazi Nnamdi Kanu from Kenya has, by operation of Nigerian law, committed an act of terrorism. Furthermore, Article 12(4) of the African Charter of the Human Rights and the People's Rights, which is binding on Nigerians and domesticated as a part of Nigerian law, provides a non-national legally admitted in a territory of a state party to the present charter may only be expelled from it by virtue of a decision taken in accordance with the law. No such decision was ever made by any court in Kenya. No extradition hearing was ever conducted. Mazi Kanu was blindfolded, tortured, and bundled onto a private jet in Nairobi in a criminal enterprise more akin to Cold War era rendition than anything permitted under contemporary African or international law. This is a matter that goes beyond the merely legal technicality. The adoption of Mazi Nnamdi Kanu is a constitutional desecration, a betrayal of international obligations, and now under the Terrorism Act 2022, an indictable offense. He urged Justice James Omotoshi to act in accordance with his oath to uphold the constitutions and the laws of the Federal Republic of Nigeria by inviting both the prosecutor and the defense to address the court on the implications of the Kenya judgment and the applicability of Section 23F2 of the Terrorism Act. Let it be clearly stated that to Nigerians and to the international community that any court in Nigeria proceeding to trying Mazi Nnamdi Kanu in defiance of the due process clause of extradition law and in a willful disregard of a treaty obligation is not only violating the Constitution, it is aiding and abetting terrorism. Those hoping to circumvent Nigerians' own law should not so carefully. The Terrorism Act 2022 defined the trial of the persons illegally adopted in a breach of of an international treaty as a terrorism itself. In other words, every sitting of the court that proceeds without first securing the foundational illegalities of this rendition is itself an unlawful act. This is the shame and the disgrace that Abubakar Malawi and those who continue to defend his illegalities have brought upon the Nigerian state. A trial built on illegality is itself illegal. A court that closes its eyes to jurisdictional abuse loses moral and legally legitimacy, he added.